Okay, hello everybody. No, I'm just getting started. Let me check my frame for everyone who's joining. Let me just make sure I've got everything set here. Welcome, everybody. Welcome. I want to make sure I've got my little piece in place just to make sure. Welcome. Now let me see if I can get this lined up. How am I? Am I in frame? Am I in frame, everybody? Hello, welcome. Yes, I'm in frame. Okay. Good evening. Slide to the left, right? Looks good. Oh, good. So, oh my gosh, we have so much for tonight. I'm going to just wait a few minutes here to get everybody in and join, but we've got a lot of stuff that's been going on. Yes, the letter from yes. Oh my gosh, I have read that. It is absolutely fascinating. Fascinating. Yes, good to see you too, everybody. Yes. Welcome. Yes, I'm glad to see you. Hi, Sherry. Hi. Oh, it's been so busy. Today has been busy. So, oh no, Miss Funny is not playing. No, she most certainly is not. Oh, that's so nice to see, Kia. I appreciate that. Oh. So, yes, we've got several things that have been going down today, a couple of pretty major things. So I will absolutely be going through um, each of these tonight. So absolutely. Yes, read exhibits F through O. I know, that was the best part. Best wishes from Scotland. Well, thank you kindly. Thank you so much. Do I need help moderating? I should be okay. But that is so kind of you to offer. That is so kind. I tell you what, if you don't mind, would you be able to help moderate tonight? I would appreciate that actually. I'll go ahead and add you on, and feel free to pop in and out. You don't have to stay the whole time, but whatever you're comfortable doing, I'm very thankful for that assistance. I appreciate that. So this is still warm. I just printed this out. This is the order from the judge denying the removal to federal court. So I will be going through this tonight, and I will also be going through the special purpose grand jury. I had done a post before on the special purpose, but they'd only given out some of the information. But today they have let most of the information come out. Oh, Cozy and Cray, hello, welcome. Thanks for coming. Yeah, I wanted to pop on just a little bit early and kind of just say hi to everybody and make sure we could get everything kind of set up in place. So yes, hot off the printer. Yes, it is. It's toasty. It's toasty. Oh, yes. Do a dramatic reading. Well, we'll see. I'm not sure. Oh, yes. Well, we've had so many things going on. I was like, you know what? We will definitely go through both of these huge documents that came out. Huge as in their impact is huge, not huge as in they're difficult. Am I muffled? Okay, let me see. Let me see if I can get us sorted here. There we go. All right. How's that? Is that better? Okay. Oh, love the nails. Thanks. Thank you. Yes, I just had my had my last bit. Am I glitching? Oh, okay. So I'm okay. I'm better. Let me see. Still muffled. Hold on. Let me see what I can do about that. Hold on just 1 minute. Let me readjust my tech here. There we go. How's that? Is that better? I readjusted things a little bit. The sound is better. All right. I may need to... Hello, Rosie. Welcome. Sounds good. All right. Let me do one more adjustment here to see if I can work on this a little bit more. So I have to get more tech savvy, I think. So, oh my goodness. Oh, am I in a tunnel? I should be better now. Oh, hello, Greg. Welcome, welcome. All right, we got it. Better? Okay. Oh, good, good, good. Yes, I needed to readjust uh where I was at. So, yes. Oh, I'm glad. I'm glad. Excellent. Glad to hear it. I'll just wait just a few more minutes. I've got a couple of people. Did I get out of the well? I'm so glad I was able to get out of the well. Ah, oh, thank you. Yes. I'm just, I will be now, just to keep everybody straight, since we do have a couple different documents, I will be switching my rings out in between documents. So I figured that would be a good way of figuring out which document we're talking about. So maybe center the paper. Yes. Once I get going here, I'll be able to I just got a stack here, but we'll definitely kind of switch things up a little bit. Nothing in constitutional law that allows what's going on. So, right. Okay. Very good. Aloha, I'm catching you on your day. Oh, thank you. Thank you so much. Yes, tonight I've just got kind of a mixed bag for nails. I just was like, let's just do this for fun. This is, I think it's a topaz. Is that right? It's very similar to my other ring, but it's a different size. So, good evening. Yes, welcome, welcome. Welcome. Oh, thank you. Thank you. Yes. So this will be the first ring for the first order, but then I will change them out as we move into the next one. So, oh, it should be pretty fun. Oh, I do love the citrine. My citrines that I have are a bit more yellow. So because this is more of a, caramel color, I think this is, oh, is it Mary? Oh, love that. November baby then. Oh, I love that. 300 carat. No. No, nothing that big. Love the color. Oh, thank you so much. Oh, topaz. Yes, it is one of my favorite stones. So, yes, I've got a couple different, hello, Daisy, welcome. So I do have a couple of different orders that came down today. We've got two things. We had the special purpose grand jury out of Georgia that we had some information on before, but a lot of it was redacted, wasn't permitted for the public. But today we have a big chunk of it that was released to the public. And then also just printed it, still a bit warm. And this was the denial for Mark Meadows. So I thought we could go through that. I wanted to take some time to go through each document here. Now, I do also have, for those who are interested, I am going to try at the end of the live, we'll see how things go. But this is the petition from Colorado in order to not put Trump onto the ballot. So we've got a question that's been posed, and there have been a couple of different petitions that have been kind of circulated, one out of New Hampshire, one out of Florida, but the Colorado one I thought was pretty good. So I thought I would go through that at the end here. I'll hit the documents just to update everyone on the court cases first, and then I'll go into the petition and kind of go through the petition next. So we'll see how far we get. We'll have to take some breaks, but it should be a good one for tonight. All right, I'll just wait a couple more minutes here. I'm just waiting on a couple more of my moderators to join me. Happy Friday to you as well. Happy Friday. Yes, it's good to see everybody. Yes, there's a lot going on, Emily. There's a lot. I've got a lot, but I think we'll be able to manage it. Oh, thank you, Sean. Thank you. Welcome. You've got the lemonade ready. Love to hear it. Love that. Oh, yes. Oh, hi, Kim. Hello. And Michelle, good to see you. Jim, A4, nice. Good to see you. Yep, we've got boop boops going on. I just made some popcorn. Oh my goodness. Yes. Oh, I think that's important. Happy Friday. Yes. This is difficult. These are challenging things, but we also need to find that little glimmer of humor where we can. Oh, Russell, thank you. Thank you. That's so sweet. I appreciate that. Yeah, boop, boop, everybody. Yes, we're going to have a pretty good time. I think we've got some interesting information. Will the decision have an effect on the others? I think it will, Greg. And as we go through, we can see the judge's analysis on why he decided the way he decided. So I think that'll be really good because we can apply that to all of the other 18 defendants. I think it'll be pretty helpful. So it should be fun. It should be fun. Yes. Oh, thank you, Mildred. Thank you. That's so nice of you to say. I appreciate that. I really appreciate that. Yes, I've been going live the last few days. I tend to go about this time. This works out really the best for me. I know it's may not work for everybody, but for me, it works out the best. So cat juice, where did the boop boop come from? Okay, so here's the story of the boop boop. Here's my boop boop mushroom guy that hangs out with me. He fights off the trolls. But the boop boop came from a speech that Mr. Trump gave on January 6th. He was talking in his speech, and one of the phrases that he said during his speech, and I was reading the transcript, was he said boop boop. And we all just kind of paused and were like, I'm sorry, what did he say? But he used the phrase boop boop. So ever since then, we just kind of boop boop around. Oh my gosh. Is it the same federal judge for the other 4 who petitioned to remove it to federal court? I'm not sure exactly how the judges would work. It seems like this judge, because they have knowledge of the situation, this is Judge Steve Jones, that he would be the one to kind of be pulled in because it's all the same facts. But, I'm not sure exactly how this court would work at it. So I'm assuming it would be the same judge, but that's a soft yes. As we would say in the business, that's a soft yes. Soft yes. Oh, yes, I'll be watching it. I'm going to try to figure out a way to be able to kind of watch it, stream it, and do some commentary as we go through it. So we will see. We will see. Shirt, cuffs, nails. Oh, thank you. Yes. But I will be there. So you think all are not going to be able to move? Well, I'm not sure. I've not read through it yet. It's actually still a little bit warm. But as we go through it, I think it'll be helpful to kind of point out where I think good points would be for any of the defendants, all of them. So I think that'll be helpful. Come into play. I haven't seen him, but I also have not read the entire special purpose grand jury either. So this will kind of be my first noticing of these things as well. So we will see, but I did not note him actually involved in there. Yes. Oh, hello, VC. Good to see you. Wonderful to see you as always. So Lindsey Graham got lucky. I agree. He did. He did get lucky. Have you made it through the RS documentary yet? I haven't. Actually, I was doing a little bit of research on the indictment we went through last night. So that's really where I've spent some of my time at. So I will need to. It's on my list, but got to take it in small bites because it's a lot. It's a lot. I wonder if there would be a lottery for the trial. I will camp out overnight. Oh my goodness. Yes, I don't know. That case was a lot. It really was a lot. I think we all had to stop for a minute. The Meadows rejection to move to federal court from Fulton. Yes. So I've got the 2 documents here, and I think we'll be able to make it through in pretty good time. The first is going to be, I've got the Mark Meadows removal denial that was just sent down, and I just printed this out right before I came on tonight. And then we've also got the order for the special purpose grand jury, the final report that's been entered into the record. Now, I've read pieces of this before, but it wasn't all made public until today. So these are the first 2 documents I want to start with. Of course, I always have, this is the Georgia indictment. I've always got this at the ready because it's really important. And then after those documents, I'm going to try to kind of crack open the Colorado petition to get Mr. Trump off of, or not put him on the list for the primaries in Colorado. So this is a very interesting petition. I do want to kind of get started on this. We may not make it to this tonight or to very much of it, but I definitely want to talk about those 2 orders that came out today. They're just so important for the situation. So it'll be busy, yes. So feel free to pop in and out as interested, and it should be pretty fun. All right, so let me just take a quick question. I'm assuming everyone would want to be to hear the Meadows decision first. So would this be better to kind of start here? I'm just wondering. I'm trying to get a feel for who all is here. Okay, Mark Meadows, yeah. Mark Meadows. Oh, Perry Mason, always good to see you. Always good to see you. Love that. Appreciate that. And wonderful to see you. Now, VC, I think I've got you set to be able to block. So if you're seeing any of the complete anti-negative, really bad trolls, go ahead and block them tonight, because we're going to need to start being a bit stronger on our stance on blocking. Everyone else, I've got you set to mute, and they will be muted for the entire live. Just not playing around. Got too much to do tonight. So, but yes, thank you, VC. I absolutely have 100%, 120% faith in you. So appreciate that. Any negative opinions are okay. We just ask that everyone be respectful. And when we're talking about differing opinions, that's fine. But severe name calling, racism, prejudice, those kinds of things, we just don't do that here. And blatantly incorrect information, specifically regarding the election, that is a huge no-no for the TikTok world. And so the community guidelines are very, very careful about that. So we just need to be careful. So let me get my water opened here, my lemonade water. And then we will just crack into this. Is this decision appealable? No, it's not. No, because of the authority given to the court in order to determine jurisdiction. So once a judge has determined jurisdiction and tossed it back to the state court, no, it's not appealable. All right, so let's crack this bad boy open. Let me just make sure I'm in frame. Am I in frame okay? It looks to me like I'm a little bit crooked. I just want to double check. Oh, welcome, Dr. D. Good to see you. All right, am I in frame? Not appealable. Nope. Yep, got the lemonade. A little off. Yeah, I'm wondering, am I crooked? Just tell me when I'm in a good spot. Slightly. How's this? Is this okay? Okay. So I'm going to go ahead and tape this off so that I stay in frame. Sometimes things can get a little bit bananas as we go through the live. So I will do my absolute best to keep it in frame. I know it absolutely drives people bonkers when I get out of frame. It drives me crazy too when I watch the playback. I'm like, what? Get in frame. Oh my gosh. So I will do my best here to make sure I can stay in frame for everybody. All right. So hopefully I'm good enough. Hamburgers and coffee. Love to hear it. All right. So if I am in frame well enough, I've got 2 different views I'm looking at. So I'm just trying to make sure. All right. Excellent. I think others will file a motion. We will see. All right. Here we go. Here's our order. This matter appears before the court following defendant Mark Meadows' filing of a notice of removal. This order addresses a relatively narrow question. We've got, has Meadows carried his burden of demonstrating that removal of the state of Georgia's criminal prosecution against him is improper under the federal officer removal statute? Having considered the arguments and evidence, the court concludes that Meadows has not met his burden. Therefore, the court declines to assume jurisdiction over the state's criminal prosecution of Meadows under 28 U.S.C. of 1455 and remands the case to Fulton County Superior Court. Because the court lacks jurisdiction over this matter, the court directs the clerk to terminate all pending motions and close this case. So here's the key.
When we have a case like this where we're removing under this statute that they're talking about, the notice of removal is given, but then we're already in federal court. So it's up to the federal court to kick it back to the state. So that's why it's been remanded. Then anything else on file with reference to this, so if there were any other motions going on in court, they would all be terminated. So that's what this language means. Okay. Background. Now, this is the analysis we're going to be looking at and keeping in mind all 18 other defendants. So if any of the other defendants in this case are going to try to remove it, and we've already heard from a couple people, then we're going to look to the analysis here and see if it's applicable to everybody. That's where the key is here. So Meadows served as White House Chief of Staff. So he had the biggest position other than the president. Defendants Exhibit 1. His tenure began March 31st of 2020, ended January 20th of 2021, when President Biden assumed the office of the President of the United States. Yes, it's boy, Roy, I tell you, not having footnotes and citations yesterday was something else, wasn't it? Oh my goodness. All right, on August 14th, 2023, a Fulton County, Georgia grand jury returned an indictment charging 19 defendants with various crimes related to alleged post-election interference with the 2020 presidential election in Georgia. Now, we've got here, we've got a citation, and we're going to bump down. Again, we've got this remand, so it takes us here. The court has not actually assumed jurisdiction over this case under Section 1455. So the court's just clarifying this section. Why they're saying it's remanded is just a technical piece. So back up we go. On August 14th, right, the grand jury returned an indictment, 19 defendants, various crimes to alleged post-election interference, right? I've already gone through this line, so let me just pop. I'm going to be careful with these terms again because the platform that we're on right now is extremely sensitive to these terms. So just kind of, you'll have to excuse me on that, but I'm being careful. So the indictment charged all defendants with conspiracy under Georgia Racketeer Influenced and Corrupt Organizations Act. This is a Georgia RICO Act. It also charged different co-defendants with other violations, various criminal violations. Fraud was charged. We had impersonating a public official charged. We had some computer trespass, invasion of privacy. So we had lots of other criminal violations. In the indictment charges, Meadows specifically, with the RICO conspiracy and solicitation of violation of oath by a public officer. His two charges that Meadows was charged with, one was for the call to the Secretary of State. The other was for just being a part of the conspiracy. So those are his two counts. Meadows argues that the charges against him relate to the scope of his official duties and that he has colorable federal defenses. Based on those arguments, on August 15th of 2023, Meadows filed his notice of removal of the criminal prosecution in this court. Relying on 28 U.S. Code 1455, Meadows asserts federal officer jurisdiction under Section 1442. The court declined to summarily remand Meadows' removal action and ordered an evidentiary hearing be held on the notice of removal on August 28th, which seems like 2 years ago, doesn't it? Although it was just not that long ago. Pursuant to Section 1455b5, the court also ordered the state to respond to Meadows' notice of removal, which it did on August 23rd. Meadows replied on August 25th of 2023. The same day, the court permitted amicus curiae, or amicus curiae, that means a friend of the court, to file a brief in support of declining jurisdiction. Before the hearing, Meadows filed a motion to dismiss and an emergency motion to enjoin his arrest in Fulton County, Georgia. The motion to dismiss remains outstanding on the court's docket. The court denied Meadows' emergency motion under 1455. So let me just stop here for a second real quick. He had two motions in play. He had wanted this emergency motion to keep him from needing to be showing up at the Fulton County Jail, which we all know already happened. So that motion had been dismissed. His motion to dismiss claimed different grounds based off of the supremacy clause under the Constitution. It's intrinsically woven together with his motion to remove this, but it's still on file. It means the court's not decided it yet, just so you know. So this is still open, and that's okay. Now, what they're saying here, which expressly mandates the state court criminal proceeding continue until the federal court notifies the state court that it's assumed federal jurisdiction over the prosecution. On August 28th, the court held a hearing on Meadows' notice of removal. Meadows personally testified, and here we go. We've got a citation. Let's just bump right down into it so we don't lose our place. At a criminal trial, the state has the burden of proof. Thus, at a criminal defendant's trial on the merits, he never has the obligation of presenting a defense or testifying, and those choices can never be held against him. U.S. Constitution, the Fifth Amendment, of course. For a notice of removal, however, the defendant has the burden of establishing subject matter jurisdiction. Now, under this section, which is 1455, this section of the U.S. Code, again, just states if you're a federal employee and you're being sued or you're being prosecuted, you can remove it to federal court if you were acting within the scope of your duties as a federal employee. That's the key here. All right, so back up. Meadows personally testified and, through counsel, admitted a number of exhibits, including 2 declarations of persons who worked in the White House at the time he was the White House Chief of Staff and were familiar with his role in the administration as Chief of Staff. The state called Kurt Hilbert, an attorney who represented President Trump and the Trump campaign in 2020, the Georgia Secretary of State, Brad Raffensperger. The state also admitted a number of exhibits, including an audio recording of the January 2nd, 2021 call between President Trump, Secretary Raffensperger, and others, in which Meadows participated, states Exhibit 3. Now, I have played that phone call multiple times. It is up on my Tube of You channel for anyone who's interested in listening to that phone call, along with, my commentary pulling out different pieces of evidence. At the conclusion of the hearing, the court took the matter of its jurisdiction over the criminal prosecution under advisement. The court subsequently ordered post-hearing briefing regarding the role of the indictment's alleged overt acts for purposes of determining applicability of the federal officer removal statute. Again, we have 161 overt acts that were listed in the Georgia indictment. The parties timely submitted the requested briefing. Having considered the arguments put forth by the parties, the evidence submitted at the evidentiary hearing, and the briefing on this matter, the court now enters this order concluding that the court lacks federal jurisdiction over Meadows' criminal prosecution. This is the key. So again, we have Meadows charged with the RICO count along with the phone call. And during the phone call, they're saying he solicited the Secretary of State to break his oath and commit an offense that would be in violation of the Secretary of State's oath. That's what the charge is. So the court is saying here they do not have jurisdiction. So it would be relatively easy then to attach this fact that federal jurisdiction doesn't apply here to the other defendants. But let's see if we can find more of an explanation. Legal standard. This will be the key. This is the case law then that will decide whether or not we've got jurisdiction in federal court. A federal district court should be slow to act where its powers are invoked to interfere by injunction with threatened criminal prosecutions in a state court. And we're citing the Johnson case, the Douglas case, both of those, 68 and 43. There's a strong judicial policy against federal interference with state criminal proceedings. This is the Manny-Penny case, quoting the Hoffman case. An exception to those general concepts of federalism is the federal officer removal statute. Again, this is the code section. The statute allows for federal jurisdiction over a criminal prosecution against any officer or any person acting under that officer of the United States for or relating to any act under color of such office. Federal officer removal is an incident of federal supremacy and is designed to provide federal officials with a federal forum in which to raise defenses arising from their official duties. Now, let me take a moment. This federal supremacy is a reference to Article 6 to the U.S. Constitution, the Supremacy Clause. So let's just clarify that. That's what they're saying when they use that phrase. However, because of a preference for state courts conducting their state prosecutions, removal of a state criminal prosecution requires a more detailed showing of the relation between the acts charged and the federal role at issue. Furthermore, federal courts must maintain a balance between the Section 1442 allows and respect for the state's right to deal with matters properly within its domain. Meadows removed this criminal prosecution under Section 1445, which provides the procedure for removing a state criminal prosecution to a federal district court. Now, this section of the code merely provides procedures that must be followed in order to remove a criminal case from state court when a defendant has the right to do so under another provision, citing case law here. Upon filing a notice of removal, the court must promptly determine whether the notice and its attachments clearly fail to establish the court's subject matter jurisdiction. And if they do, the case is summarily remanded to state courts. 1455b4. If summary remand is not granted, then the district court must promptly hold an evidentiary hearing to determine the disposition of the prosecution of justice that shall require. So based on the facts adduced at the hearing and arguments put forth by the parties, the court must determine whether the defendant has met his burden in establishing that the court has subject matter jurisdiction over his criminal prosecution. Now, subject matter jurisdiction, legal term, you find all jurisdiction issues, subject matter, and so on under the Article 3 of the U.S. Constitution, which sets out the federal courts. So they're citing case law here. Under 1442, the question of scope of the federal officer's authority contains issues of law and fact. And everyone has been citing this case, defendants as well as government. Determinations of whether an employee's actions are within the scope of his employment involved a question of law and fact. Ultimately, for removal under this section to be proper, the removing party must show that there's a basis for the federal court to exercise jurisdiction over criminal prosecution. A removing defendant bears the burden of proving proper federal jurisdiction. Now, as a quick side note again, the state or the government bears the burden to prove proof beyond a reasonable doubt in order to find guilt. But in an action like this, stating this should be a federal court situation, the burden shifts to the defendant to show that. If the court lacks federal jurisdiction, then the case cannot proceed in this forum. The Supreme Court has cautioned that an airtight case on the merits in order to show the required causal connection is not required, and that courts are to credit the movant's theory of the case. The movant is the person who has requested the case to be removed. So this would be the defendant. I'll just put, this is a symbol for defendant. Typically, legally, this would be a symbol for the government. This is a defendant's symbol, just so you know. So the defendant's theory of the case for the elements of the jurisdictional inquiry. The point is only that the officer should have to identify as the gravamen of the suit, so as the basis, the primary point of the suit, an act that was, if not required by, at least closely connected with the performance of his official duties. And this is a quote from Justice Scalia, who was dissenting. Okay, so there is our standard already. Yes, where can you find this document? It is online. You can just use the search term Georgia versus Meadows, federal court holding or federal court decision. You got it. All right, so let's get into the analysis here. To determine whether Meadows is able to remove based on federal officer jurisdiction, so this section of the code, the court must answer the following questions. 1, whether Meadows was a federal officer during the time of his allegations in the indictment. This will play a key part for everybody. 2, whether the charged conduct in the criminal prosecution were undertaken for or related to Meadows' color of office, meaning is it in his job description as chief of staff. Now let's bump down to the citation here. This is 6. Acts taken under color of office must be either vested with or appear to be vested with the authority entrusted to that office. This means, although there's not a specific job description for chief of staff, this needs to be kind of a well-known part of the duties of chief of staff that is vested within their duties. So this, again, is just kind of a legal standard for what actually his job description is, which isn't clearly specified. And 3, whether Meadows has put forth a colorable federal defense for the criminal prosecution. The state concedes that at the time of the events alleged in the indictment, Meadows was a federal officer and his role was the White House chief of staff. Thus, the court must next evaluate the second question of whether the acts in the indictment relate to his role as White House chief of staff. Again, keep in mind his 2 charges. He's got one for RICO and one for the phone call he was involved in to the Secretary of State in Georgia. To determine whether the charged conduct was undertaken for or related to Meadows' color of office or his duties as chief of staff, the court must A, define the act allegedly undertaken by Meadows in the indictment, B, ascertain the scope of the federal officer role of the White House chief of staff, and that's going to be kind of tough to do, and C, analyze whether Meadows showed that the acts in the indictment were for or related to the role of the White House chief of staff. So let's start with A. The federal officer removal statute. The court must define what constitutes an act under Section 1442. Then the court must assess how the act functions under the RICO statute. Finally, the court will establish the contours of the act as they relate to Meadows in the indictment. Now we've got a citation, so let's bump down so we don't get lost. The court primarily focuses on the indictment's RICO charge because the other charge against Meadows, soliciting a violation of oath by a public official, is also alleged as an overt act, with evidence submitted in support of the RICO charge. So what the court is saying here is that not only is he charged with his own code section for that particular offense, let me just show you that. So he's charged with count 28. So RICO's count 1, here we go. RICO's count 1, which has 161 bad acts. One of those acts is the phone call. And count 28 is a separate count just for that phone call. And that count is the one where they're asking the Secretary of State to violate his oath, is what they're saying there. So this is the phone call. So he's charged with this count. This exact language of this count is mentioned as one of the overt acts. So because of that, they're saying we don't need to address both things. We'll just take it one at a time since we'll be talking about the same situation. That would be Act 112 here, okay? So Act 112 and count 28 are the same thing. Right, for everyone who's following along at home with your own indictments, which I'm sure everybody has a copy of. As we go through all of this, my goodness. All right, back into it. So he's saying, look, we'll take care of it at the same time. Next, number 1, Section 1442, the text and the precedent. The pertinent portion, now again, this is this section everyone is going to be using to try to move their case. It provides a criminal prosecution that is commenced in the state court and that is against or directed to any officer of the United States in an official or individual capacity for or relating to any act under color of such office may be removed by them to District Court of the United States, meaning to federal court. The phrase for or relating to any act under color of such office modifies the earlier clause. So it has an effect on the prior piece of the clause. A criminal prosecution that is directed against or directed to an officer of the United States. This structure indicates that the criminal prosecution must arise from an act that is for or relating to the color of a federal office, even if a criminal defendant can characterize individual instances of behavior as part of his official duties within the broader charged conduct. This is not enough to convey specific or convey subject matter jurisdiction on this court. This is the key here. So let's just pause and take a moment and back up. Even if a criminal defendant can characterize individual instances of behavior as part of his official duties within the broader charged conduct, all right, so this is important because in RICO, you're charged with the conspiracy. You're not charged with the piece that you played. You're charged for the entire conspiracy. So they're saying some of the things that were involved in RICO, some of the acts, maybe he was acting as part of his role, but it's not enough to convey subject matter jurisdiction to this court. So just because some things he did were under the color of his office did not mean everything was, and that does not establish subject matter jurisdiction for federal court. So put differently, facts indicating that a criminal defendant at times operated under the scope of his federal office will not provide this court with subject matter jurisdiction under Section 1442 unless the state is criminally prosecuting the officer for those specific acts. This is the difference between a regular charged act and a RICO act. That's the key. RICO is the Racketeer Influenced and Corrupt Organizations Act. So a group of people getting together for a common enterprise using two or more racketeering offenses in order to complete that common goal. All right. There we are. Now back in. This interpretation is consistent with others' courts analysis. Specifically, courts have looked at whether the claims or charges related to acts taken within the scope of federal office. And we're citing 8. Let's bump down. Claims in a civil action correspond to charges in criminal prosecutions. So the judge is saying, hey, we're using claims for civil and criminal interchangeably. So don't let that mix you up. In Nadler, which is the precedent case for everything here, the 11th Circuit suggested that the district court had subject matter jurisdiction where one claim is cognizable under Section 1442, quoting case law. Therefore, the court looks at 1, what the charges are against the federal officer, and 2, whether the charged conduct is for or relates to the color of the federal office. So this is the test he's referring to. The cases cited by Meadows support the proposition that courts look to the whole claim alleged, not just isolated facts supporting the claim, to determine whether Section 1442 has been satisfied. And then we're quoting the Hines case. A federal officer can remove a criminal proceeding commenced in a state court where the criminal charges involve actions taken in an official and individual capacity. And then we're citing another piece. We're citing the Pensacola case. If the complaint contains even one federal claim, then the defendant has the right to remove the entire case. And this is what Mr. Meadows was arguing during the hearing and in his briefs. Now we pull in the Sawyer case, finding removal where an officer asserts a federal defense to even one claim. Thus, the court looks at the criminal charge to determine whether the charge relates to the scope of Meadows' federal office. To satisfy the scope of federal office requirement, so this is one of the pieces, the officer must show a nexus, a causal connection between the charged conduct and asserted official authority. This is under the Acker case. The Supreme Court has articulated the following test for the undercolor of office requirement. Has anyone noticed how much we love using tests in the legal field? There's a lot of tests going on in here. All right, here's the test. Let's look at the test on whether or not this is under your duty as a federal officer. Let's see. There must be a causal connection between what the officer has done under asserted official authority and the state prosecution. It must appear that the prosecution of him for whatever offense has arisen out of the acts done by him under color of federal authority and in enforcement of federal law. And he must, by direct averment, exclude the possibility that it was based on acts or conduct of his not justified by federal authority. Under the 11th Circuit jurisprudence, which is key, this is the holding case law, a key factor is determining applicability of the federal officer removal statute, is whether there is a causal connection between the state's charges and an act of defendant that forms the basis of those claims. The court notes that the RICO charge against Meadows presents a novel question in the case. Most cases invoking federal officer removal involve claims based on discrete actions taken by a defendant. For example, in the Hines case, the defendants were charged with the discrete acts of felony this, aggravated this, with a this, burglary, false statements, and violation of oath by a public officer. A RICO conspiracy alternatively involves wide-range allegations of illicit and licit activities undertaken by an association of individuals and in furtherance of a criminal enterprise. The state's prosecution in this case is illustrative of the conspiracy charged here is alleged to have occurred over many months, including at least 19 individuals, and encompassed 161 overt acts. So he's really distinguishing this RICO situation from any other kind of case. And again, the RICO, what sets RICO apart is that we have this conspiracy. So the conspiracy element is a plan made by two or more people. So the plan itself is the charge. It's not the actual act. So conspiracy to commit bank robbery. The bank robbery is the crime. That doesn't have to occur, but it's the agreement to do the bank robbery that would be the conspiracy charge. Although RICO conspiracies are rarely removed under Section 1442, the court is not without some precedent to guide the analysis. In 1982, the 11th Circuit evaluated whether an FBI agent as a federal officer had a federal immunity defense under the Supremacy Clause against the Georgia RICO charge. And this is the Martin case. The 11th Circuit, hold on, there's a quick citation here. It would behoove me not to cite it. So let's bump down to 9. This case was not a removal case. Rather, it was a federal suit filed by the officer to preemptively prevent the commencement of a state criminal prosecution. So this case was actually about trying to prevent the prosecutor from bringing charges. So they're making that distinction. The 11th Circuit affirmed the district court, who found that the sole overt act alleged against the FBI agent related to bribing a state court judge. The district court found, and the 11th Circuit affirmed, the conduct charged against the FBI agent was taken within the scope of the agent's federal office because the bribery occurred during the execution of a state and federal criminal investigation into judicial corruption. All right. So, on the other hand, the Fourth Circuit Court of Appeals held that the district court did not err in declining to exercise jurisdiction under Section 1442, where the heart of the plaintiff's claims did not relate to the scope of federal duty. In that case, a civil complaint alleged that defendants, as agents of the United States, contributed to a climate change by producing, promoting, selling, and concealing the dangers of fossil fuel products. Alteration in the original, and so this citation's been altered a bit. That's what that means. The Fourth Circuit affirmed the district court's finding that defendants did not show a basis for federal officer removal by looking at the complaint as a whole. The Fourth Circuit determined that while some activities were arguably within the scope of the federal office, i.e. the production and concealment of hazardous fossil fuels, was controlled or directed by a federal officer, the lack of federal control over the production and sale of all fossil fuel products is relevant to the nexus analysis. All right, so we've got two pieces. We've got what is the scope of their job and what is the nexus. So both of those need to be included. Moreover, even if production and sales were controlled or directed by a federal officer, the heart of the claims asserted was concealment and misrepresentation, which did not remove to the defendant's official duties. Ultimately, the Fourth Circuit concluded that the activities relating to the official duties, i.e. production and sales, were too tenuous to the allegations of concealment and misrepresentation to support a removal under 1442. Thus, under the text of the statute, binding authority and persuasive authority, Again, binding authority means from the actual jurisdiction, so that's 11th Circuit. Persuasive authority means information or case law from a different circuit, so that's the 4th Circuit. So that's persuasive versus binding. The court finds that act in the federal officer removal statute is best defined as the heart of criminal charge. With this in mind, the court now turns to the charges at issue in this case. So now we will step into the Georgia RICO charge. Is everybody following along okay? Are we making sense out of this explanation that is quite a bit? Light bulb moment. Does not appealable mean dismissed with prejudice? It's not officially dismissed. It's been kicked back. So at the very beginning, the judge was saying, we do not have jurisdiction. We just had this question of whether or not we could take the case. And we're saying we can't. So you can have it back. So jurisdiction was not established by this notice of removal. I appreciate you. Oh, you're welcome. Can you please recap what this document is? Yes, this is the, all right, so Mr. Meadows had put notice in Georgia to remove his case to federal court. There's a specific statute that allows for federal officers to remove their case to federal court if they're being charged at a state level in a civil case or a criminal case. This statute allows for removal. It's just one of those things. So he was saying, I was acting under my duties as chief of staff, which is a federal position. And because of that, I'm covered by the statute and should have my case heard in federal court, even though it's state charges and a state prosecutor would still go with it to federal court. So a hearing was put on, evidence was put on, and different case law was presented, briefs were presented. The court then today issued an order declining or the accepting of jurisdiction, meaning they're saying, I know you want to remove it here, but that's too bad. We don't have jurisdiction. So it's being kicked back down to state court to actually be tried. Yes. Yep. They didn't establish jurisdiction. Isn't a jurisdiction statement required when filing? Right. So the key here, what they're saying is when looking to subject matter jurisdiction, that's what he's explaining here. He's saying, we've got standards for what's under color of your job. And the question was he really doing things within the scope of his job? That needed to be determined by the judge. This was kind of a first impression situation because we haven't had a chief of staff saying, hey, this was my job. No chief of staff has ever come out. Even Nixon's chief of staff has said specifically, this kind of action was within the scope of my job. No one said that, so it needed to be determined. The other one was it connected enough to his job in order for it to be removed to federal court? And the judge is saying no, and he's explaining why through case law. So this whole thing is about the fact that there isn't subject matter jurisdiction. There isn't, because his job is not connected enough to the acts that were involved. Yeah. Oh, yeah, of course. That's why I'm here. I'm here to try to help explain this language. Can Meadows appeal? No. When it comes to jurisdictional questions, right, it's left up to the courts to make a determination. So if a federal judge is asked to hear a case and determining that they don't have jurisdiction and that's appealed, you're basically saying to that court, you don't even know your own jurisdiction parameters. That would be pretty bad. That would be a huge hit to our judicial branch, because you're saying this lower court, I'm going to go talk to somebody better and bigger than you and tell them to force you to take a case you already said you don't have jurisdiction for. So it's possible in some situations to do that, but not in something as simple as making the determination of whether or not subject matter jurisdiction exists. Right. So let me, if you'll just give me one moment here, let me see if I can pull up the case I'm thinking of to support that. So just 1 second. Right. I'm not getting the case pulled up. Sorry. I'll have to come back and cite the case later. I apologize for that. But Yeah, it's at this point, what I will say again is just, it's up to the court to determine jurisdiction. If we've got a constitutional law question, if we had a constitutional issue going on, we can appeal that. But we've got a federal judge saying we don't have jurisdiction to hear your case. So it's possible then once the case is finished to appeal and say, this was incorrectly decided in the wrong jurisdiction. I suppose you could try that avenue. But to have jurisdictional questions like this is not an appealable issue. I will need to pull the case that I'm thinking of that gives it. But the judge is also going into this as well, stating that they have the jurisdiction to determine subject matter jurisdiction. Habeas corpus is an act is a writ where you have been incorrectly held in custody. So you need to be in custody in order to apply for a writ of habeas corpus. So you're saying I'm being held in custody against my will illegally, and we want a judge to hear it. That's what habeas is. How does the Hatch Act play to this? I'm not sure yet. I'm curious as to whether or not the judge will bring it in. The Hatch Act, of course, makes it illegal for federal employees to actively campaign under the umbrella or scope of their job. Court of last resort in the circuit said no. That's a great way of putting it. Right. And it has to be for constitutional law, habeas. Yes, that's correct. That's correct. But again, the habeas corpus is that act where you're saying I'm being held against my will. The only other kind of writ would be a writ of mandibus or a writ of mandamus, where you're asking a higher court to force someone to do something, to force a lower court to do something. Very, very rarely used. Very rarely used. It does. Yep. All right. So let's jump back in and see if he talks about the Hatch Act. I think that would be a really good question. The Georgia RICO charge. The indictment charges Meadows and his 18 co-defendants with engaging in a RICO conspiracy to violate RICO statute. RICO statute provides that it's unlawful to conspire or endeavor to conduct or participate in, directly or indirectly, such enterprise through a pattern of racketeering activity. So they're explaining what an enterprise is here. An enterprise is defined as any person or association or group of individuals. That's the key here. We don't have to have an incorporated group. Associated, in fact, through, although not a legal entity. So the enterprise itself need not be illicit. For purposes of this case, a pattern of racketeering activity requires at least 2 acts of racketeering activity with the same or similar intents results. Accomplices, victims, or methods of commission or otherwise are interrelated by distinguishing characteristics and are not isolated incidents. Racketeering activity includes the commission or attempted commission or solicitation, coercion, or intimidation of another to commit a variety of Georgia criminal statutes. It also can include violations of certain types of state or federal laws outside the state of Georgia. The RICO conspiracy charge only requires at least that one co-conspirator commit an overt act to affect the object of the conspiracy. While not specifically defined in the RICO statute, the Georgia Supreme Court has indicated that an overt act under the general conspiracy provision means a specific type of open or manifest act made in furtherance of conspiracy to commit a crime. Now, I'll pause for one moment and just note for anyone who was on my live last night when we were going through the other Georgia RICO, this is what I was talking about when I was saying we were not dealing with racketeering activity. This is what I'm referring to. So you have to have a specific act in furtherance of the conspiracy to commit the crime. Just kind of clarifying that for those that were on last night. Critically, for conspiracy crimes, the indictment need not set forth the particulars of the overt act. And we're citing case law here out of Georgia. Indeed, the government is not required to prove the overt act specified in the indictment, nor must the state ultimately prove that each co-conspirator defendant committed an overt act, so long as one co-conspirator committed overt acts in furtherance of the conspiracy. So only one person has to be found to have committed the overt acts, and then everybody involved in the conspiracy is held accountable, is liable for that. In sum, to establish a RICO conspiracy, the state only need prove that any co-conspirator committed one overt act in furtherance of the conspiracy, whether the overt act was specifically charged in the indictment or not. In other words, the state can prove the RICO charge against Meadows by showing any one of his co-defendants committed any overt act in furtherance of the conspiracy, whether that overt act is in the indictment or not. Let me highlight that. This is an essential piece for everyone to understand when it comes to a Georgia RICO. This is what we're trying to explain to everyone. That is a very difficult concept for people to understand. And, I get it. It really is a bit different. Only one person, one of the 19 defendants, committing any overt act in furtherance of this conspiracy. Everybody is charged. Everybody's held responsible. Everybody. That is the key to the RICO case. The overt acts alleged against Meadows are specifically include, but are not limited to, attending a meeting with President Trump and Michigan officials about election fraud in Michigan, messaging a United States representative from Pennsylvania, meeting with Pennsylvania legislators about election-related special session, requesting a memo regarding disrupting and delaying the joint session of Congress on January 6th when electors' votes were to be counted, physically attending and observing a non-public Georgia election audit recount, arranging a phone call between President Trump and Georgia Secretary of State's chief's investigator regarding the Georgia presidential election results, messaging the chief investigator about the potential for a quicker signature verification of Fulton County election results if the Trump campaign assisted financially. That was particularly a devastating moment. That's Overt Act 96. And soliciting Georgia Secretary of State Brad Raffensperger to violate his oath of office by altering certified returns for presidential electors. That's Overt Act 112. Count 28 also. When the indictments named overt acts are not elements of the RICO conspiracy charge, the court still finds that they are relevant evidence for whether Meadows' association with the enterprise related to his role as White House Chief of Staff. To clarify, under Georgia RICO, the overt acts are not elements of the RICO charge. Again, this is a key piece to understanding how RICO works for everybody. All right, so they're not elements of the RICO charge. They're used to illustrate the existence of the conspiracy. So the actual existence of the agreement and various alleged co-conspirators' association with the conspiracy. Georgia law makes clear that the state need not prove the existence of any particular overt act to prove its RICO claim. Nor must the state prove any of the overt acts that are currently alleged in the indictment, because the act defined by Section 1442 means the charge against Meadows under Georgia's RICO statute, his criminal prosecution is removable when his association with the conspiracy relates to the color of his federal office. For those of you that were with me when we went through the government's brief explaining this is exactly what she said. She said, we do not have to prove that Mr. Meadows did these individual acts under the scope of his office. We have to prove that he was involved in a conspiracy and that involvement was not under the color of his office. This is exactly what she put in her brief, just to remind everyone. Right. Oh, it's so awesome. Oh, you're so funny. Prosecution doesn't have to prove any of the acts. We have to prove, what he's saying is that let's go back to his language. Let's use his language. In other words, the state can prove its RICO charge against Meadows or anyone by showing any one of his co-defendants committed any of the overt acts in furtherance of the conspiracy. That's the genius of the RICO charge. That's what makes RICO so effective, is because you don't have to find proof beyond a reasonable doubt for each of these acts. All they need to find is that someone committed any of the acts in order to further the conspiracy. That's the burden of the state. Yeah. So the judge is setting it out again. in here. So again, he's saying, look, all we have to show, all the state needs to show is that him being involved in the conspiracy, not the acts, but the conspiracy itself, the agreement, was not under the color of his office. That's the key. Next, number 3, the alleged act taken for purposes of federal officer removal. So let's go into his analysis on that. Federal officer removal is appropriate when the gravamen or heart of the charge relates to the federal office. As stated above, the court determines that the actual act alleged against Meadows is the RICO charge, not the overt acts. Again, this is so important. And also what the DA had put into her brief. So the RICO charge is the key, not the overt acts. The overt acts are what makes RICO possible. Section 1442 requires the court to determine if Meadows was acting within the scope of his federal office in the alleged act of associating, this is the key, in the act of associating with a conspiracy to violate various Georgia criminal statutes. Put differently, the act at issue for purposes of the indictment's RICO charge is Meadows' alleged association with the conspiracy. So his association is the act. That is the RICO charge. The overt acts, however, by and large, only serve to tell a broader story about the conspiracy to unlawfully change the outcome of the election in favor of President Trump, but they are not the source of criminal liability. Again, that's the key to this entire case. The conspiracy, the agreement is the RICO charge. The acts just support that the agreement was in place. This is the exact, what we've been talking about. What are inchoate offenses? What is a conspiracy? So that's the key when we're dealing with RICO. That's the key to it. Okay. The court acknowledges that even though it was not required, the state chose to include these overt acts in the indictment. Unsurprisingly, Meadows structured his evidentiary presentation to the court and his briefing around the 8 overt acts in which he was mentioned. I'll pause right here. Again, when we were going through his response brief, rather than discussing the conspiracy, his entire defense was that each of those acts were under his job description, rather than discussing and working on that conspiracy issue. And that's why he went down a completely different road than what was needed in order to prove he was part of the conspiracy because of his job, which is what he needed to get it removed to federal court. Following the hearing, the court itself ordered supplemental briefings, this is the briefing that I'm talking about, on the issue of whether a finding that some, but not all overt acts involving Meadows acting under color of federal office was enough to trigger the removal statute. And to be sure, defining Meadows' act as associating with the alleged RICO conspiracy does not preclude assessing the overt acts alleged. And we're citing the Bochum case again, evaluating overt acts alleged against the FBI agent to determine whether his involvement in the conspiracy was for his federal duties. Accordingly, the court's subsequent discussion of the relating to requirement for federal officer removal includes an analysis of the overt acts in order to determine whether Meadows' association with the alleged conspiracy, the conduct for which he was charged, so his association is the conduct, all right, related to the scope of his federal duties. Because the inquiry hinges on whether Meadows' association with the conspiracy related to the color of his office, however, jurisdiction is not conferred simply because of a single overt act. Is it legal to question an election? Yes, absolutely. But if you file legal suits, you don't commit crimes. Exactly, Daisy. You got it. That's right. We had over 61 suits filed, and every single suit was dismissed. And actually, the majority of the suits were dismissed by the people that actually brought the lawsuits. So the petitioners dismissed their own suits. And in some of the cases, they dismissed them 5 days after they filed them, if you look into any of those cases. All right. Overt act relates to Meadows' federal office. After all, the indictment alleges a series of associative acts spanning over a year, and the overt acts attributed to Meadows span 3 months. So I think that's important as well to kind of visualize what we're dealing with. His acts in particular were within 3 months, but all of the acts for the conspiracy were over a year. Undoubtedly, during that time, Meadows performed actions for or that related to the color of his office. But the relevant inquiry is what activities go to the heart of Meadows' participation in the enterprise. Can you touch on color of office, please? Absolutely. So color of office, there's a couple of ways that he's defining it. He's saying we've got a couple different routes and what exactly it means by color of office. Let me pull up the exact language he uses here, okay? This is the test he's using. This is the Mesa v. California case. There must be a causal connection between what the officer has done under asserted official authority and the state prosecution. It must appear the prosecution of him or whatever offense has arisen out of acts done by him under color of federal authority. So they're saying he has to have, because of the authority he's granted as a federal officer, his duties given to him by federal authority means under the color of his position. So there must be some kind of an attachment between his job and the authority granted to him by the federal government. And the test goes on, in enforcement of federal law, and he must, by direct averment, exclude the possibility that it was based on acts or conduct of his not justified by his federal duty. So under color of office means his duty granted to him by the federal court or by the federal government. Does that make sense? Conspiracy is not asking the question. The conspiracy is trying to manipulate the answer. Oh, that's a good way of putting it. Right. And actually, I mean, it's even broader than that. The conspiracy is even asking about it. You can just, by sitting down and saying, you know, let's, what would be a great thing? Okay, so let's go to the cookie shop and take over the cookie shop. And you can talk about that all you want because everyone, you know, you're hanging out, playing pool, talking about cookies. So talking about it, that's fine. But then when you sit down and you make a list of everything you're going to need in order to take over the shop, how many people are you going to need, where are you going to put the bodies, all of those things, how are you going to get the cookies loaded up, all of those are seen as overt acts towards taking over the cookie shop. So just talking about it, that's fine. But when you start making a list and buying supplies, now we're in trouble. Now we're in overt acts. And getting milk. Yes, getting milk. Oh, the cookies. Well, yeah, I mean, there's people working there. If you're going to take over the cookie shop, you got to get them out of the way, right? How are you going to get them out of the way? These things have to be planned. I'm just using this as a hypothetical. I'm not actually writing this down. This is not actually an agreement between other people and myself. This is just an example. Lollipops do not count. Oh, yeah, glue. Yeah, I think buying glue just because you need glue isn't in furtherance of the crime. That would be something different. Oh, goodness. Oh, for 3 cookie jars. Oh, my gosh. The elves need the cookie jars. Oh, my gosh. All right, here we go. Back in. All right. Undoubtedly, during the time Meadows performed his actions for or that related to the color of his office by the relevant inquiry is what activities go to the heart of Meadows' participation. You're priceless. This is so great. How wonderful. Oh, Jennifer, that's so sweet of you to say. I appreciate that so much. I appreciate it. Participation in the enterprise and whether those activities relate to the scope of his federal office. If they do not, then Meadows cannot satisfy his burden of establishing subject matter jurisdiction under the federal officer removal statutes. So Meadows' role as a federal officer. So let's get into that. Having defined the act at issue for federal officer removal, the court now turns to Meadows' federal office and its scope. This inquiry is necessary because the authority of Meadows' office will dictate the scope of his duties associated with the role. So what we're doing now is we're trying to figure out if his duties include being involved in the conspiracy, not the acts, but being involved with this agreement. At the evidentiary hearing, Meadows testified broadly to the scope of his role as White House Chief of Staff. He also ordered 2 declarations to further I'm ordering cookies in my mind right now. Sorry. He also offered 2 declarations to further describe the Chief of Staff's role. Meadows also testified about his role specifically in reference to the indictment's overt acts. Now, if we bump down, we've got a citation. The court admitted these declarations over the state's objection and indicated that it would assess the weight to be given the declarations given that they are unsworn and unnotarized. So this is a note saying that the court just allowed the documents to come in and would say, I'll take a look at whether or not they're actually reliable. So Meadows testified about his role, specifically in reference to indictments overt acts. So that flips us to the next piece. The White House Chief of Staff role. So this is what I'm interested in. Are we actually, what is the role of the Chief of Staff? Let's get into that. Meadows was the White House Chief of Staff and assistant to President Trump from March 30th until January 20th. Assistant of the President and Chief of Staff. He described himself as the senior official in charge of the executive office of the President, indicating Meadows had broad responsibilities, including advising and assisting the President, managing the staff of the White House office within the executive office of the President, asserting that Meadows was responsible for keeping the trains running on time for the White House and the executive branch of the federal government. Meadows described his position to require overseeing all the federal operations, which extended to actions taken inside of and outside of the West Wing. Specifically, Meadows testified that he was part of almost every meeting with the president, either as principal or as observer. That seems like a lot. I hope he was compensated for that. Meadows' general practice was to attend many but not all the meetings between the president and other parties, regardless of subject matter. In meetings, principals may have a particular position regarding a particular issue and would try to show the pros and cons of the arguments so that some resolution could be made. Even as an observer, he attended the president's meetings because his job required him to try to be aware of everything in the meeting, even if he was not a principal. Meadows was responsible for administering the planning and scheduling of the president's meetings, telephone conferences, and other engagements, regardless of subject matter. These meetings might include members of Congress, other executive branch officials, and state or local government officials, indicating that the Chief of Staff was responsible for managing the president's calendar, arranging meetings, calls, and other discussions with federal, state, and local officials, as well as private citizens. Meadows testified that as Chief of Staff, he had to be aware of the president's schedule. This meant he would move meetings along, do the wrap-up, and bring things to a close where there was an action item. And if other executive branch staff were in the meeting to ensure, Meadows asserts that another function of Meadows' role in the White House Chief of Staff was to be generally aware of what's going on, because he often was called upon to give the president advice. It also helped Meadows prioritize the president's time and skate to where the puck is on certain issues. Oh, right. I forgot about the hockey reference. There we go. That's a reminder. Hold on. Here we go. We've got a puck involved. Oh my goodness. The hockey. All right, hold on. I'm going to just hook in an extra battery source. So give me 1 second here just to make sure. Sometimes this can help. Oop, if there's any glitching, this can be helpful. There we go. That should put us back into place again. Sorry. Here we go. All right. Hopefully we're back. We're back in frame okay. Is everything okay? Drop the puck. I know I did. I dropped the puck. Oh, all right. Good. Excellent. Yes, I will hydrate. 1 moment, please. Okay. So we're in. Thank you. Thanks for looking out for me. Appreciate that. Get so excited about paperwork. Oh, all right. So we're in hockey puck land. Now, Meadows also testified that as White House Chief of Staff, he was bound by the Hatch Act. All right. So here we go. Here's some Hatch Act information. So we bumped down. To be clear, no Hatch Act violations has been charged against Meadows, and the court is not determining if Meadows violated the act or if there was any merit to a potential Hatch Act claim. which is fair because you can't charge Hatch Act violations. That's not how the Hatch Act works. And he could not engage in political activity according to the Hatch Act. As discussed more fully below, the Hatch Act prohibits an employee from using his official authority or influence for the purpose of affecting the result of an election. This includes using his or her official title while participating in political activity. And political activity is defined as activity directed towards the success or failure of a political party, candidate for partisan political office, or partisan political group. The court finds that the color of the office of the White House Chief of Staff did not include working with or working for the Trump campaign. Whoa, gotta get the highlighter. It's highlighter time here. The court finds that the color of the office of the White House Chief of Staff did not include working. Whoops, highlighter. This is like my 15th highlighter this week. Working with or working for the Trump campaign, except for simply coordinating the president's schedule, traveling with the president to his campaign events, and redirecting communications to the campaign. All right, this is a key finding here. So the court's saying, I'm not going to get into the Hatch Act, but I am going to say that none of the political activity that you're talking about is included in your job description. That is not included. Thus, consistent with his testimony and the federal statutes and regulations, engaging in political activities exceeds the outer limits of the office of the White House Chief of Staff. So these political activities, not included in your role. 2. Meadows' testimony and theory of the case. Meadows' theory of the case is that he's entitled to immunity because the indictment relates his role as White House Chief of Staff. As part of his direct and cross-examination testimony, Meadows addressed how the overt acts related to his specific federal role as White House Chief of Staff. Ultimately, Meadows concluded that based on the topics and circumstances discussed in his testimony, he had not done anything outside the scope of his role as the White House Chief of Staff. However, he did admit that there could be activities the president requested which would be outside of the scope of his role. While the court credits Meadows' testimony about his role as White House Chief of Staff, it will give greater weight to the testimony of specific tasks that he outlined as within the scope of his office, i.e. time management, attending meetings, briefing the president, etc. Meadows testified consistently about these duties on both direct and cross-examinations. Additionally, these duties are corroborated by the declarations filed in support of Meadows' notice of removal. However, the court gives less weight to his assertions that all actions he took were within the scope of his office. When questioned about the scope of authority, Meadows was unable to explain the limits of his authority. This is a key piece as well. The court likes to have parameters involved, and by not having any limits is too much. Courts don't like that. Other than his inability to stump for the president or work on behalf of the campaign. The court finds that Meadows did not adequately convey the outer limits of his authority, and thus the court gives that testimony less weight. So because he could not clarify his role, his testimony is less significant. This bumps us down to this citation here. In this case, Meadows was the main witness presenting testimony for his case. Thus, the court must determine the appropriate amount of weight to assign to his testimony when evaluating it, the same as it does any other witness in an evidentiary hearing. However, given the nature of the motion and the pending criminal proceedings, the court makes these decisions with great caution. The determinations here do not go to Meadows' propensity to be truthful as a general matter. This language is really important for if we're going to use any of his testimony in court. So the testimony that he gave during this evidentiary hearing could possibly be used in a criminal case. But what the court is saying here is that it's not making a determination about the propensity for truthfulness. These words are key because if we have a propensity of truthfulness issue, we can use specific pieces of testimony we normally would not be able to use. So the court's just distinguishing this in case it needs to be used in other court hearings. I don't think he confessed. I think the judge is just saying, I'm not going to determine whether or not his information is trustworthy. I'm just saying in my situation, I need to take a look at it because of the burden that I bear to have it. I think it's interesting, though, that he's setting this out. I think it's interesting. Yeah. Go ahead, VC, and delete those when those pop up. If you have a chance, when you're not doing a million other things. All right. C, Rico Meadows was not acting under color of office. I hope I said block instead of delete. So we're at a point. Just a moment here. Sorry, everybody. I just need to make sure we're keeping a nice, our moderators are so amazing. You are all, each one of you are muted. You muted them all. Wonderful, Deborah. That's fantastic. Thank you so much. I appreciate it. Yeah, we're just, we're kind of at a point now where I'm taking a look at the mutes after the lives, and, some need to be blocked. We're just kind of at that point. I think we're just getting to the numbers now, honestly, in my account here, where we got to kind of take care of things. So, yeah. Oh, absolutely. Oh, the moderators. I'm so thankful for all of you. Oh, so thankful. So thankful. Okay, here we go. The court now turns to whether the acts alleged against and taken by Meadows are related to the color of his office as White House Chief of Staff. It ultimately concludes the relevant acts are outside the scope of Meadows' federal office. Highlighter time. Here we go. Ultimately concludes. This is key piece as well. This can be argued in any court's filing that happens from this point on. Oh, I know. I've got a little something special I'm working on for my moderators. I'm so thankful. Don't give it away. It's a secret. All right. Number 1, federal and statutory limitations regarding the scope of the office of White House Chief of Staff. A, constitutional requirements. The Constitution does not provide any basis for executive branch involvement with state election and post-election procedures. The Elections Clause expressly reserves the times, places, and manner of elections to state legislatures. That's a really important piece. Let's highlight that. I think somebody really needs to know what this is. So this is the U.S. Constitution, and it actually sets out times, places, and manner of elections to the state legislatures. Look at that authority. So it's actually not up to the vice president. It's not. That's excellent. We love that. The framers of the Constitution intended the states to keep for themselves, as provided in the 10th Amendment, the power to regulate elections. Ooh, so important. So important. Love this. Love this. That's right. It means business. I'm not messing around with a pink one. Oh, the framers understood the Elections Clause as a grant of authority to state legislatures to issue procedural regulations, and not as a source of power to dictate electoral outcomes, to favor or disfavor a class of candidates, or to evade important constitutional restraints. Did the judge come up with these arguments, or was it the prosecutors? This is the judge. There's a blend of, he's going clearly through the state's arguments as well as through the defendant's arguments. So he's analyzing both of them and then going back in and making his holding based off of that. States have been tasked under the Elections Clause to provide a complete code for elections, which ought to include regulations relating to prevention of fraud and corrupt practices in counting votes. Citing the U.S. Supreme Court, this is not a power incident to a state's police power, but derives from an express grant in the Constitution. And none of this language, by the way, was included in the government's brief, just FYI. Courts have previously faced tough questions in cases involving Congress's power to use its lawmaking authority to oversee or empower the states in their duties under the Election Clause. The Supreme Court has recently and repeatedly reaffirmed that the power of the Elections Clause confers is none other than the power to preempt. The clause is a default provision. It invests the states with responsibility for the mechanics of congressional elections. So important, but only so far as Congress declines to preempt state legislative choices. Indeed, when the Supreme Court has discussed federal power limiting states' authority over elections, it's cited to congressional power, not executive power. Wow. So we even have a limitation on any of the power to congressional power as opposed to the executive branch. All right. Conversely, there are no similar close calls presented when executive authority is at issue. As a constitutional matter, executive power does not extend to overseeing states' election. Now let's bump down. We've got our first citation. The only potential constitutional authority, the Take Care Clause, does not enable the type of election oversight to which the state's indictment pertains. This is also an incredibly important piece as well. The judge is even starting to set out some of the arguments that we're going to see, I think, in the DC case. The president shall take care that the laws be faithfully executed, yet executive authority under the Take Care Clause does not extend to government officials over whom the executive has no power or control. The court accordingly rejects Meadows' suggestion that the Take Care Clause provides a basis for finding executive authority over state election procedures. All right, so I would say this whole piece right here, this is what's going to chip away at his argument that he's protected by the Supremacy Clause under the Constitution, because the judge is saying what you were doing does not fall under the duties of the executive branch at all. If anything, it's under the congressional branch, but it's actually up to the states. I think that's very powerful. I think that's an incredibly important footnote here that we will see again. So just noting that the court is also unpersuaded by Meadows' contention that his acts involving the state election procedures are within executive power to advise Congress. Now, remember, again, one of the big things he was saying was that he was involved as a way to kind of keep up with what's going on and to figure out how to go about giving information to Congress, if anyone remembers that. What is the Take Care Clause? So Meadows was saying that it's within their purview as the executive branch to make sure that the elections run properly. So they kind of specifically what he was saying was he had to keep an eye to make sure, what was the words he was using, that we had free and fair elections, and that if there were problems, he could figure out a way to talk to Congress about it. I don't know if you remember that particular wording that he used, but and so I'm just pulling up I'm trying to see if I can pull that exact piece out of the Constitution here. Let me see. The Take Care Clause. Where did I find that? Right. So let me, of course, my Constitution. Oh no, it's a little further away. Oh. Okay, so under the Article 2 of the Constitution, because of course we have to look exactly to the Constitution in order to get the words. Let me make sure I've got it. Compensation. Let's see. So, hold on here, just 1 second. He shall have the power to grant reprieves, pardons, consent of the Senate, right? Shall appoint. Vacancies. State of the Union. Here we go. He shall take care that the laws be faithfully executed and shall blah, blah, blah. So this is the Take Care Clause that's in the Constitution. So under Section 3, Article 2, Section 3, So let's back up a little bit. It says, he shall from time to time give Congress information of the state of the Union, right? So that's the state of the Union, and recommend to their consideration such measures that he shall judge necessary and expedient. He may also on extraordinary occasions convene both houses. And then if we skip down between them with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. So Mark Meadows had said repeatedly in his testimony and in his brief that his goal, what he had to do, was to make sure that the elections were free and fair, and to make sure that if it wasn't going on, that he prepared whatever they needed to in order to present to Congress any kind of solutions for the fraudulent exercise of anything that he saw going on. He was claiming that it was under this section because the president is supposed to take care that the laws be faithfully executed. So this is the duty that was set out. That's what he's referring to here. And the judge is saying, nope, we're not going to do that. We're not going to do that. So Article 2, Section 3. And thank you for the question. I'm glad we could kind of work through that. Because that was his biggest piece that he had. It's not his duty, right? Well, that's what the judge is saying here. So the court is unpersuaded that his contention that his acts involving the state election procedures are within executive power to advise Congress, which is that section of Article 2. It would be inconsistent with federalism. So we're going on again. So he's specifically stating that your citation is incorrect, and you trying to claim this broad authority of advising Congress by making sure we had free and fair elections is not what is meant by that piece of the Constitution. So it would be inconsistent with federalism and the separations of powers to find that because the executive branch may advise Congress, the Elections Clause is a default provision. It invests in the states with responsibility for the mechanics of congressional elections, but only so far as Congress declines to preempt state legislative choices. Now, we're citing U.S. Supreme Court case law here. The court will not find that the executive branch has some advisory authority in this space in light of the express constitutional grant over elections to the state. That's another key piece. So Meadows was arguing the executive branch has an obligation to tell Congress if we think that there's a problem with our elections. So because, of course, a lot of what was going on was advising different state houses and senates that there was fraud, right, with their elections. That's a huge part of what was going on with RICO. So Meadows was saying under our duties to express that to Congress, we were just doing what we had to do. And what they're saying here, that's the take care clause. And so what the judge is saying here is that, no, I don't think the take care clause extends that far. And in fact, the authority specifically given to the states regarding procedures for their elections completely supersedes anything that you're saying. You misreading a line? Okay. Well, I may have, Alan. Court will not find the executive branch has some advisory authority in this space in light of the express constitutional grant over elections in the state. Right. All right. So let's pop back up. This was the citation number 13 we've quoted. I think this is really a critical piece to the entire argument. I think this will come out again in the DC case. So apart from spheres where federal supremacy supersedes, states function as political entities in their own right. Here, there's clear constitutional authority delegating the procedures of elections to the states. See Constitution, Article 1, which establishes Congress, Section 4, Clause 1. Thus, the executive branch cannot claim power to involve itself in states' election procedures when the Constitution clearly grants the states the power to manage elections under the Elections Clause. All right, so that's pretty important. Let's just take a quick moment and double check what, since I've got my Constitution here in my hand. So Article 1 is establishing Congress. Section 4. Here we go. Clause 1. The times, places, and manners of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. So there you have it. That establishes that the states are in charge of the protocols for electing anyone. I just realized yesterday was your 1 year. Oh yeah, thank you. Thank you. Yes. Yes, I may pop in some memes. I really just started with memes. I hadn't really jumped in too far at that point. Thank you. That's so kind of you. All right, key piece. We'll be coming back to this quite a bit. We'll be coming back around. Yes, it does. You're a phenomenal attorney. Appreciate you. Oh, thank you. That's so sweet. Oh, that's so kind of you. Oh, I have the best laugh. Well, that's nice of you to say. Some people say otherwise, so I appreciate that. Oh my gosh, Shelly, that's so kind of you. I appreciate that. Oh, I really do. I really do. It's been a bit of a rough week here. I've been very thankful for this week, but it's been a bit of a rough week, so I appreciate the kindness. All right, B, statutory requirements. Statutorily, the Hatch Act is helpful in defining the outer limits of the scope of the White House Chief of Staff's authority. The state argues, and Meadows agrees, that he's bound by the Hatch Act, a law that prohibits federal employees from engaging in political activity. Well, the court does not rely on the merits of the Hatch Act violation. It does recognize that the Hatch Act provides that political activity is not included in the outer limits of the role of the White House Chief of Staff. The Hatch Act prohibits executive branch employees from using their official authority or influence for the purpose of interfering with or affecting the result of an election. The federal regulation governing political activities of federal employees prohibits the same. That regulation, moreover, broadly defines political activity to be activity directed towards the success or failure of a political party, candidate for partisan political office, or partisan political group. The types of behavior that Meadows is alleged to have involved included post-election activities and election outcomes in various states pertaining to a particular candidate for office. If these potentially political activities indeed come against the Hatch Act, its regulations limit such efforts. These prohibitions on executive branch employees, including the White House Chief of Staff, reinforce the court's conclusion that Meadows has not shown how his actions relate to the scope of his federal executive branch office. Federal officer removal is thereby inappropriate. Again, that's another key piece here. So, and again, if the chief of staff isn't going to be removed, I mean, it's going to be pretty hard for anyone else just working as an advisor or as a helper to have within their job abilities, their official job titles. So this is pretty much it. This is the maiden voyage, I think, for this particular argument. The only person that could surpass this would be Trump himself if he's arguing removal because he did everything as president. But this judge has already said, I'm not going to let you use that clause of the second article in order to claim you needed to make sure that the election was free and fair so you could advise Congress. It's an interesting argument. Number 2, Meadows has not met his burden of establishing the acts are related to his federal office. Even under the quite low bar for federal officer removal, the court concludes that Meadows has not met his burden to show that his criminal prosecution can be removed under the federal officer removal statute. Although the words acting under are broad, the Supreme Court has emphasized that they are not limitless. Opining the act that forms the basis of the gravamen of suit is at least closely connected with the performance of his official function. The court concludes that Meadows has not even met, anytime they add that in, that's harsh. Meadows has not met even the quite low threshold for removal. Again, what the court must decide for purposes of federal officer removal is what the actions Meadows took as a participant in the alleged enterprise, the charged conduct, were related to his federal role as White House Chief of Staff. The evidence adduced at the hearing establishes that the actions at the heart of the state's charges against Meadows were taken on behalf of the Trump campaign with an ultimate goal of affecting state election activities and procedures. Meadows himself testified that working for the Trump campaign would be outside the scope of White House Chief of Staff. As the court has also explained, the overt acts are merely illustrative in nature and not elements of crimes charged against Meadows. Nevertheless, the overt acts are set out in the indictment, and Meadows shaped his entire evidentiary presentation around them. And that's a kick at Meadows right there. He's saying you picked the wrong argument to make during it. Yeah. Therefore, the court will assess each of Meadows' overt acts to factually determine if they fall within the scope of Meadows' role as a federal officer. Oh, this is interesting. Okay, now the judge is going to go into the acts. That's very interesting. Let's see how the judge comes out on these. The court finds Meadows only carried his burden in showing that one of the 8 overt acts attributed to Meadows could have occurred within the scope of Meadows' federal office. Overt Act 6 provides that Meadows sent a text message to United States Representative Scott Perry from Pennsylvania and stated, "Can you send me the number for Speaker and leader of the Pennsylvania legislature? POTUS wants to chat with them." Because Overt Act 6 is phrased so broadly, it is conceivable that it encompasses an activity that's within the scope of Meadows' federal duties. Okay, very interesting. The judge is making an assessment here when it comes to Act 6. He's saying it's stated so broadly in the indictment, it could be within the scope of his duties. Meadows testified that as part of his role of chief of staff, he would retrieve phone numbers of various state officials. I was asked on a pretty regular occasion for numbers. The omission in the indictment of the context Meadows sought the phone number, when coupled with the testimony that retrieving phone numbers for state officials was a routine part of his role as chief of staff, leaves the court to conclude Overt Act 6 arguably occurred within the scope of Meadows' duties as White House Chief of Staff. The court finds that the evidence presented does not show the most of the remaining overt acts were related to the scope of Meadows' role as Chief of Staff. All right, so that's interesting. The procedures, now hold on, let's bump down again. We've got a citation. At the hearing, Meadows disputed the merits of Overt Acts 9 and 19. With respect to Overt Act 9, he disputed that he participated in the November 25th meeting with the Pennsylvania legislature. Similarly, Meadows disputed that he asked McEntry for the memorandum, as alleged in the indictment hearing. Meadows is not required to show that he is innocent of the charges against him to successfully remove his case. Neither is the state required to prove the overt acts as part of its burden of proof at trial. That's so important. All right, this is another key piece. So there we go. Section 3, supra here. Accordingly, to the extent necessary, the court treats the evidence propounded in support of Overt Acts 9 and 19 as neutral to the determination of whether particular overt acts were within the scope of Meadows' federal office. So the judge is saying it's not going to matter one way or the other. I'm not going to let it be the deciding factor. I'll be neutral on it because we don't need to determine if there's a factual basis for that or not. The procedures states utilize to conduct elections and ensure results are not part of the executive branch's role or powers. As a senior official in the executive branch, therefore, Meadows cannot have acted in his role as a federal officer with respect to any efforts to influence, interfere with, disrupt, oversee, or change state elections. Those activities are expressly delegated to the states. Could you go over that pink part? Oh, sure. All right, let me make a note. So let's bump down here again. So this again, he's explaining what the burden is for the state to prove at trial for the RICO case. So this is just another piece to kind of clarify for everyone. Neither is the state required to prove the overt acts as part of its burden of proof at trial. So Meadows wasn't required to show that he did it or did not do it in order to remove his case, and the state isn't required to prove the acts actually occurred as part of its burden of proof at trial. So when we're talking about burdens of proof, we're talking about Meadows' burden of proof for this hearing for removal and versus the state's burden of proof at trial. So when she's going into trial, she does not have to prove the overt acts as part of the burden of proof. What she has to do is say that there were overt acts, they believed some overt acts occurred, and therefore the other pieces of RICO fall into place. Oh, you're welcome. Yeah, you are absolutely welcome. Does that make sense? again, we're just going through this idea that it's the conspiracy itself that's the RICO charge. It's not the particular elements. Those can be proven in different places. There are multiple counts that were charged separately from the overt acts because they are their own legal charges. But the acts themselves, they just need to find somebody amongst the group committed some of those acts. And if they did, now we've got a conspiracy. That's the key. So his acts may not be overt, but he could still be found guilty of RICO. Yes, he could actually be found to have not have committed any of those acts, and he would still be responsible. There are 161 acts. He's saying his name was mentioned in 8 of them. Even if all 8 of those, for some reason, the jury is like, we don't know, we're not sure about that. There are still, 150, math is not my strength, 150 other acts. So if any of those 150 other acts are found, any of them, just one or two of any of those, he would be guilty of being part of the conspiracy. That's the key. That's the key to it. Right. So he has been charged with his own separate count. Now, his count outside of RICO, that needs to be shown to the jury. They need to find proof beyond a reasonable doubt that he did commit the solicitation of an officer to violate their oath. That count that he was charged with needs to be found. But for a RICO, all that needs to be found is that a couple of those acts were put into place. Now, this judge is saying 1, another case is saying 2, so that's why I'm being kind of, a bit wishy-washy. I would say finding 2 of the acts would be safe. I'm not sure only 1 is needed. So if we look here, all right, Mr. Meadows, he's charged with RICO, all right? So if anybody did any of the 161 acts, anybody, he could be charged with that. But he's also charged with this separate count, number 28. That count, he needs to be found guilty of beyond a reasonable doubt. This one right here. But the RICO itself, again, any of the bad acts need to be found. Any one. So even just a finding that one of them got into the computer in Coffee County, that act could be enough for everyone to be convicted of the RICO. What defenses are there to the RICO charges? Primarily that you weren't involved, that you had no knowledge of the agreement, that you were not part of the agreement. That's going to be the key. That there was no common enterprise and you were not a part of any agreement. You have to separate yourself from everyone else. That's the only way to really go forward and defend a RICO. It's not going to be about the acts, because the conspiracy itself is the key. The key to defending against RICO is to say there was no common goal. And that's going to be pretty hard to defend, actually, because everything here they're saying was done in order to further the common goal of Trump being in for a second term, or to have interference with the elections so that, he could potentially remain in power. You're amazing, Oh, oh, I'm glad. I'm happy to be of help. I hope that is helpful in some way. The vinegar was never added to the cake is the only defense. Oh my gosh, you're right. That's a great way of putting it. Like, it wasn't added. I had some idea that something was going on, but I certainly was not involved in it in any way whatsoever. You went through a RICO trial. Really? Yeah. Yeah, there's a lot of sentencings going on this year. There's a lot going on. There's a lot. That's on who gets. Oh, no. No, we don't. We're against violence here. When are the hearings for the. Oh dear. Let me just hold on here for a second. And there we go. So back into it. Here we go. Overt Act 96 alleges that Meadows sent a text message to the office of the Georgia Secretary of State's chief investigator, Francis Watson. Now we'll bump down here. At the hearing, Meadows testified he believed the message was to Miss Jordan and not Miss Watson. So, is there a way to speed up Fulton County signature verification in order to have results before January 6th if the Trump campaign assists financially? At the hearing, Meadows testified that no federal funds would be available to the Trump campaign to support this request. Nevertheless, Meadows testified he was not speaking for the campaign in this message, but that it was in keeping of me trying to ask a person who would know whether it's financial resource issue. manpower issue or whatever. So I wasn't speaking on behalf of the campaign. Meadows failed to provide. This is helping me too. Oops, I missed that one. I'm sorry. I'm a bit behind here. I'm trying to scoot us through this language here. Sorry about that. Okay. To defend. Yes. Oh, yeah, I think so. I think it is going to be hard to defend. Found guilty, do they lose their pensions? Oh, that's a good question. I'm not sure. All right, here we go. Back into it. So Meadows failed to provide sufficient evidence that these actions related to any legitimate purpose of the executive branch. The court determines as a matter of fact, making a request to the Georgia Secretary of State's office regarding a possibility that the Trump campaign could provide financial resources to fund the recount effort, even if not directly on behalf of the campaign, is still campaign-related political activity. Thus, Meadows has not met his burden in establishing the Overt Act 96 related to the scope of his official duties. Similarly, Overt Act 92 alleges that Meadows traveled to Cobb County, Georgia, where he attempted to observe the signature match audit being performed there by law enforcement officers from the Georgia Bureau of Investigations and the Office of the Georgia Secretary of State. Meadows testified that his actions with respect to this allegation were in line with his duties because what I did was to go to Cobb County Convention Center to look at processes that they were going through. And in doing so, trying to, again, check the box to say, all right, everything's being done right here. And so there's allegations of fraud. We need to move on to something else. The court factually finds that Meadows is overseeing the state election recount process related to President Trump's reelection campaign. Meadows failed to provide sufficient evidence that these actions related to any legitimate purpose of the executive branch. Accordingly, the court finds Meadows has not met his burden in establishing Overt 92 is related to the scope of the Office of the White House Chief of Staff. Why was Harrison Floyd denied bail? Now, my understanding, Davey, was that he was actually given bail. That's my understanding. He actually did make bail and was out and had been doing interviews. Is that incorrect? Because that's the information I found. Just as a quick side note here, everybody. Yeah, he's out. He's out. Yeah, he's out. All right, so let me just check here one thing real quick. Yeah, I don't see any kind of appeal. I think somebody said it was being appealed. I don't see any appeal whatsoever here. Right. Yeah. No, that's, did someone say that it was being appealed? It's on a CNN website. CNN. Huh. All right. Let's just double check. Let's double check it. Judge rejects, right? Yeah, I mean, I don't know. I'm on CNN.com. His lawyers have appealed it. Okay, well, has not been that great lately. Yeah, I don't see it. I don't see it at this point. So yeah, I'm going to have to wait, again, until I see a court document that actually states he's appealed it. I'm not going to, that to me is not a true statement at this point. Been sketchy. Does say so. Yeah, I don't have any of that with the CNN link I've got, as well as the corroborating evidence. I don't have any appeal. I'm not going to say it would be impossible to appeal, but when we've got jurisdictional issues and a court's determining the federal court doesn't have jurisdiction, I mean, at this point, I'm trying to find. I keep thinking I've got a case at the top of my head. I'll have to pin it. Yeah, even the judge said it. Yeah, I will have to Let me pull that case. I'll put a post up on that, clarifying that piece a little bit more. But let's keep on trucking here. The court factually finds that Meadows overseeing state election recount processes related to Trump's reelection. He failed. So I've already read this paragraph here. Act 112 alleges Meadows participated in the January 2nd phone call with Donald Trump and Secretary Raffensperger. So this is the one I'm interested in because this was charged as a separate count. To unlawfully solicit the Secretary of State to alter the certified returns for the presidential electors for November 3rd presidential election. At the hearing, Meadows rationalized his involvement in this case as seeking a compromise and settlement of Trump's campaign suit against the state of Georgia. He testified this phone call setting up with the attorneys where they would find some kind of compromise. He acknowledged the lawyers on the phone call were lawyers for either President Trump personally or for the Trump campaign. See, this is a key piece. He knew who was on the phone. Oh, absolutely fair. Absolutely fair. So did he? Yeah, absolutely fair. I think if you're getting a call from the President of the United States and you're not recording it, nope. Notice of appeal has been filed. Really? Hold on. This is just absolutely driving me bonkers here. Let me see here. Yeah, I don't have it. I just don't have it at this point. So it's not, for me, that's not corroborated. I've got 25 sources that aren't saying anything on it. So I'll just go ahead and move on. Yeah, I mean, we can talk about it when I've got some evidence, but I don't have any evidence right now of that. So I'm not calling anybody a liar. I'm just saying I don't have any evidence. So if I don't have it in my hands, to me, it's just not yet. All right. Yep. We'll keep moving on. And that no lawyers from the Office of the White House Counsel or the Department of Justice were on the call. I think this is really important too, that his own counsel from the White House or the Justice says this was denied. Yeah, I don't have anything about an appeal. The Supreme Court has instructed that involvement in private litigation is not part of the executive branch's role of powers. In Clinton v. Jones, a case I have been citing. Let's just highlight this case that I have been citing in almost all of my lives lately. This is a really important case that everyone should read. Very, very important case. This one right here. Therefore, based on the evidence presented, the court finds that the January 2nd phone call was made regarding private litigation brought by President and his campaign against the state of Georgia. All right, I think that's fair enough. It was therefore outside Meadows' federal role as executive branch officer. I think that's very important. Furthermore, any participation on that call, Raffensperger testified that those were Trump's campaign lawyers on the call. So I felt it was a campaign call. In the same vein, Meadows' participation in the phone call clearly reflects campaign-related interest. Now, he said, Mr. Secretary, obviously there are allegations where we believe that not every vote or fair vote and legal vote was counted. Now, I'm not going to read this entire piece here because this language is just very inflammatory and I'm kind of watching out the algorithm. But this is a direct quote from the phone call. So he's just basically saying that they believe that there are some problems with the voting. So that's that quote there. We'll be skipping on here just to make sure. I'm careful here on my live. So the record is clear that Meadows substantively discussed investigating alleged fraud in this thing. Therefore, the court finds that these contributions to the phone call with Secretary Raffensperger went beyond those activities that were within the official role of White House Chief of Staff, such as scheduling the president's phone calls, observing meetings, and attempting to wrap up meetings in order to keep the president on schedule. Rather, Meadows' participation on January 2nd call was political in nature. Now if he is doing that, that would be a violation of the Hatch Act, although the judge has said he's not going to address that. and involved in the president's private litigation, neither of which were related to the scope of the office of the White House Chief of Staff. Now, I think it's good to note this private litigation involving the Secretary of State of Georgia. There were several lawsuits that were pending, and those had been taken care of before the actual phone call. I think that's really important to note. Very important. You are right. You will be. Oh, yeah. Oh, VC. Oh, sending hearts to you, VC. Oh, all right. By failing to adduce evidence that these actions related to any legitimate purpose of the executive branch, Meadows did not satisfy the burden of showing that these actions related to the color of his office. Finally, the court finds that activities by Meadows, even if characterized by scheduling meetings or phone calls or taken for the purpose of advising the president, are political activities under the pertinent regulations if they were for the purpose of furthering the common objective of success of a particular presidential candidate. Overt Acts 5 and 93 relate to attending, scheduling meetings, and placing phone calls. And the court finds the underlying substance of those meetings and calls were related to political activities and not to the scope of Meadows' federal office. For the meeting with Michigan state officials, Meadows testified that he recalled most of that meeting had to do with allegations of potential fraud in Michigan. He also acknowledged that President Trump had a personal interest in the outcome of the election in Michigan. Accordingly, the meeting in Overt Act 5 was outside the scope of his federal executive branch office as they related to state election procedures following the presidential election. The court also finds that Overt Act 93 was outside the scope of Meadows' federal executive role. Overt Act 93 alleges that Meadows arranged a phone call between Trump and Secretary of State's chief investigator. Now, we did have one footnote here. Let's go into this. Anytime there's information about his testimony, I think it's important. There were accidental mutings. Please forgive. Oh, yes. If there is one, just come back and message. That's okay. We just try to do our best. We've got a lot of hate coming at us pretty much constantly. Meadows later testified he did not know of any specific election challenge in Michigan by the Trump campaign or the federal government. He further clarified, however, that Trump was concerned about the election results, but in terms of a lawsuit, Meadows was not aware of it. The court finds Meadows' knowledge of President Trump's concern about the election sufficient to find that at the time of this meeting, Meadows had a general awareness of the post-election activities in Michigan regarding the state's election procedures. All right, so let's flip this. We're going to look into the investigator. Meadows admits to arranging the phone call. Meadows later testified he received this phone number either through his attendance of the Cobb County election recount or by his primary contact at the Georgia Secretary of State's office. Meadows failed to provide sufficient evidence that these actions related to any legitimate purpose of the executive branch. Accordingly, the court finds that Meadows failed to carry his burden in showing the Overt Act 93 was in the scope of Meadows' official role as chief of staff. I wish you were my law school buddy. You're outstanding, so selfless. Oh, that's so sweet of you, Katrina. Anytime you've got questions, you just message me. I'm happy to help. Happy to help. As set forth above, the court finds insufficient evidence to establish that gravamen or heavy majority of overt acts alleged against Meadows relates to his role as White House Chief of Staff. The state has put forth evidence that at various points during the time of the alleged conspiracy, Meadows worked with the Trump campaign, which he admitted was outside the role of the White House Chief of Staff. In light of the state's evidence that Meadows undertook actions. Let me just make sure. Am I in frame okay, everybody? I'm sorry. I'm just double checking here. Okay. That Meadows worked the Trump campaign and admitted it was outside the role of the White House Chief of Staff. In light of the state's evidence, okay, excellent, that Meadows undertook actions on behalf of the campaign during the time period of the alleged conspiracy, Meadows was required to come forward with competent proof of his factual contention that his actions involving challenges to the outcome of Georgia's presidential election results were within his role as chief of staff. His efforts fall short. There must be a causal connection between what the officer has done under asserted official authority and the state prosecution. It must appear that the prosecution of him for whatever offense has arisen out of the acts done by him under color of federal authority and in enforcement of federal law, and he must be direct averment exclude the possibility that it was based on acts or conduct of his not justified by his federal duty. This is that indented paragraph before. That's the test. Instead, the evidence before the court overwhelmingly suggests that Meadows was not acting in his scope of executive branch duties during most of the overt acts alleged. Even if Meadows took on tasks that mirror the duties that he carried out when acting in his official role as White House Chief of Staff, such as attending meetings, scheduling phone calls, and managing the president's time, he has failed to demonstrate how the election-related activities that serve as the basis for the charges in the indictment are related to any of his official acts. As the substance of the overt acts constituted a significant part of Meadows' testimony and proof of his acting within the scope of his federal office, the court concludes that based on the factual evidence, Meadows was not acting in the scope of his office for the purpose of federal officer removal. So there we have it. There's the key. The court concludes he was not acting within the scope of his office, and therefore the statute key piece for removal is not applicable. Count 28. Now, this is the phone call specifically. So, count 28 of the indictment is substantively the same as overt act 112 in the RICO charge. The court has already determined that the January 2nd phone call was not related to Meadows' role as the White House Chief of Staff. For the same reasons, the court determines that Meadows' participation on this phone call was not related to the color of the office of the White House Chief of Staff. Thus, Meadows has not met his burden in establishing that count 28 related to the color of his office and that the court lacks subject matter jurisdiction over that claim. So, again, we have no subject matter jurisdiction even over the next count. Federal defenses. The third prong of the Section 1442 removal requires the defendant to allege colorable federal defenses. Meadows asserts that he has immunity from charges under the Supremacy Clause because he was acting pursuant to the scope of his office. In his motion to dismiss, he asserts a First Amendment political speech defense and due process defense because Meadows has failed to carry his burden with respect to charged conduct relationship to the scope of his federal office. The court declines to address Meadows' defenses. All right, so that's a bold piece. The Superior Court may have to decide these issues at a later time, and evaluating them here should be avoided unless absolutely necessary. The principle of federalism shows that federal courts must not interfere in state judicial processes because the state courts of general jurisdiction are authorized and competent as frontline fora to adjudicate all relevant questions of both state and federal law. That's a really key holding as well. Federalism. Finally, the court finds support for its conclusion that Meadows was not acting in the scope of his federal officer role for